A citizenship question will not be included in the 2020 census for now. Yesterday, the Supreme Court ruled that while adding the question is constitutional, the justification provided for adding it was not. The issue was remanded back to the Commerce Department for a, quote, non-pretextual explanation.
So the High Court also dismissed challenges by voters in North Carolina and Maryland related to gerrymandering. The court ruled that partisan gerrymandering challenges to electoral maps are political questions that are not reviewable by the court. Joining us to explain the significance of these rulings is the former assistant U.S. attorney and professor at the University of Baltimore School of Law, Kim Wehle. She served as associate independent counsel during the Whitewater investigation and is the author of How to Read the Constitution and Why. Thank you for being here, Kim.
Thanks for having me.
Of course. So we have these big decisions that are out of the Supreme Court. It's very, great timing that we have you here. Let's start with gerrymandering, which is what I'm really interested in, which is, what was the legal standard that the court decided it's a political question? Inherently meaning you basically have to move this to the U.S. Congress, which is an all but impossible task.
Right. It's a let's send it back to gerrymandering to fix gerrymandering.
Right.
There isn't.
Great. It's a great
the legal standard isn't really a standard, which is
Yeah.
also the irony, because the court essentially said, we're not taking this. The majority said, we're not going to take the question of political gerrymandering because we don't have a standard. So we're going to use this essentially standardless concept of a political question doctrine, which is there's 11 or 12 factors. It hasn't been used that often. It's really a gut kind of instinct. I don't want this, and it's dubiously grounded in the Constitution, frankly. So that's, I think, another intellectual dishonesty here. We don't have a standard on the merits, so we're going to use this standardless really test to not take the case at all.
That's interesting.
Yeah.
Well, also it really makes it so that it makes gerrymandering pretty much part of our system as part of the future as we know it. I mean, it really does remove the ability for anybody to do anything about it for quite a long time, which has a big ramifications for our system.
Massive ramifications. Yeah. And Elena Kagan's dissent talks about how gerrymandering now can be so sort of granular in terms of the kind of technology we have. So district drawers can go sort of house by house and kind of pack and stack or crack and stack, how they explain it, that essentially put so many people in one district of one party that the minority is not going to be heard, or take a district and break it into multiple districts so that your vote is diluted. It's really damaging, very, very damaging to democracy. And frankly, the idea that the court can't come up with a standard isn't consistent with what the court's done on all kinds of constitutional questions. Yeah, it does it all the time. It comes up with standards.
So this doesn't have any impact on issues like using race to gerrymander districts. This is purely about using political party affiliation and performance as a proxy for making these choices.
Yeah, well, that's one of the, I think, critiques of the majority, is that the court has addressed racial gerrymandering, and they could make a standard like looking at intent. So if what you're trying to do is enhance the power of an incumbent, entrench an incumbent in a political position, regardless of what the voters want, if you have that evidence, then we're going to interfere. In the dissent, Justice Kagan was like, we can make a very, very high bar to get the really bad stuff and at least clean that part up. But no, I think at this point, we're living with it forever, and it's a real. Even the majority admitted it's a problem for democracy. So it's a very puzzling decision, in part because this is nefariousness that happens on both sides of the aisle. Right? We had two cases.
Bipartisan.
Right. We had Maryland gerrymandering by the Democrats. We had North Carolina gerrymandering by the Republicans. It's it's equal opportunity ousting voters, and the rule. Basically, the core concept of our democracy is that our votes matter. And this is basically shrugging that.
Well, let's also talk about the census. This was a huge decision from the court, surprised a lot of people. What exactly did they rule? There's a lot of confusion on what the exact ruling was, because they said the validity of the question is fine, but the explanation given was not. Why does the explanation matter in the view of the court?
Because this is one of the most wonky, difficult areas of constitutional law, frankly. Basically, the court considered the question under a statute called the Administrative Procedure Act. So when Congress gives agencies powers to make laws, we call them regulation, there's a challenge saying, some people say, Justice Thomas, listen, only Congress can create laws. How can agencies make laws? So essentially, in the Census Act, Congress gave the Department of Commerce the power to make laws implementing the census. And under this statute, the Administrative Procedure Act, when Congress gives agencies the power to make laws, they have to have really good reasons for why they come up with that outcome, because they're not democratically accountable.
Yeah.
You can't throw Wilbur Ross out of office at the ballot box. So under that statute, you have to have good reasons, and the court basically sent it back under that statute, which is very, very common. That is how this would normally function.
Okay.
It would go back to the agency. The agency has to come up with a better reason. It can be pretextual. It just has to be justified, and the court said, here, this is out of nowhere. This is not consistent.
Does the concern that's been raised about the conservative activist and his interaction, the guy who died and his family found all these papers saying that perhaps this was the reason why the Trump Justice Department was going after adding this question, was in effect to try to limit the number of people of Latino, Hispanic descent for signing up for the census. Does that have any bearing on this decision? Do they throw this back to sort of give people time to suss out the true facts around that story?
I think that wasn't part of the record of this case, so the court probably didn't take that into account. And that is really weighing on bears on a different question, which is an equal protection constitutional challenge to that question, which I think is probably moot at this point.
But what if what if the Commerce Secretary, if his rationale was not his true rationale?
Well, it's so long as the way the statute works, if you have enough in there to justify your stated rationale, you're okay. And the court said, listen here, the Voting Rights Act, there's nothing in the record justifying that this was why this question was going to be answered. And so you can't just sort of say this is what we're going to do and not give rationales for it, because you're exercising legislative power. The power belongs in Congress.
So
that's kind of the constitutional theory.
So that's interesting. So you can actually lie to the court as long as you have evidence that your misrepresented position is legitimate.
Well, lie is a strong word. I think the way it works is if you have, this test is called arbitrary and capricious. If basically you've dotted your I's and crossed your T's, and you have a standalone, coherent, legitimate rationale that makes sense based on the record, if behind the scenes you really had a different agenda, the APA, the statute, isn't going to stop it.
Pretty amazing.
But you can't sort of just say, we want it this way, and so sign me. That doesn't work.
Yeah.
The court's going to say, listen, you've got to give a better rationale than just that. That's essentially the theory.
Another thing I want to talk to you about is about court packing. It actually came up last night in the debate. Bernie Sanders says he's not for court packing, but for rotating justices in and out. Part of your book is about the Constitution, but the whole book is about the Constitution, but it doesn't tell us how the Supreme Court actually has to function, its composition, and all of that. What do you think about court packing? And it really is a growing movement in the Democratic Party right now.
Yeah. Court packing is one example of how constitutional boundaries are being pushed beyond their historical limits today, and why I say in the book we have to be really careful, regardless of politics, how much we are pushing democracy and the Constitution structure somewhere else. Of course, when you mentioned, the book does talk about the structure of the judicial branch, and it's shocking, I think, to most people. Congress tomorrow could abolish the entire federal judiciary, with the exception of one justice on the United States Supreme Court. Yeah. So there's really also, FDR tried to pack the court.
Sure.
There's nothing stopping.
Didn't work out very well for him.
Yeah, politically, there's political pushback. But right now we don't have a Congress that is. If Trump tomorrow were to say, listen, I want 4 more justices, I'm going to appoint them. The question would be, would the Senate confirm him? If the Senate confirms him, they better add some chairs.
Wait,
there's nothing in the Constitution.
The House wouldn't have a say.
They don't have to pass an act?
No, I think under the Constitution, it says that Congress can create the lower federal judiciary. There would be a challenge to it. You might say, listen, Congress has to weigh in on that, but the president has appointment power, and so that would be,
That's incredible.
Can
we hide this segment so that they don't see it in the White House?
Well,
I'm nervous you're going to give them ideas.
Sorry, I actually asked Trump at the Rose Garden about this. He promised he would not pack the court. So
this is the Merrick Garland thing too. Obama could have said, listen, there's nothing in the Constitution that says that the Senate has to actually hold a hearing. I give you 48 hours to give your advice and consent. If you don't, don't, by the end of 48 hours, I'm going to swear him into office. This is kind of brass knuckle tactics.
Wow.
And generally...
Very Marbury versus Madison.
I mean, we see it playing out. And I think people assume that the Constitution is a cop on the end of our driveway that's going to come in and save us.
Yeah.
We have to be vigilant.
So you said the question was around packing the court. I think there's another question that's moving around progressive circles, which is whether or not we should have term limits for justices, and whether or not justices should serve for 18 years, let's say, and then they rotate off and then bring on new justices.
That would take a constitutional amendment, because it says in the Constitution
for life, right?
that they're for life.
Even if they're still life-term judges, they just are, retirement status.
They're off by impeachment. That's how they get off, and that's in the Constitution. I think that would be close to impossible to change unless it were. I can't even imagine. We couldn't have term limits for justices without a constitutional amendment, and I don't see the energy around that. But that being said, there are a lot of institutional rules in the Senate for how justices are vetted, and that's kind of under the radar. That process under McConnell has gone really, really partisan. That is, we don't now have the blue slip where a senator from the opposing party can basically say thumbs down on a candidate. We don't have respect for the American Bar Association saying that candidates to the federal bench are not sort of legitimate, or they don't pass the basic competence test. That's gone out the window. We have a shorter time period for actually debating and looking into candidates' backgrounds. All of that, I think, is really unfortunate for the institution of the federal judiciary. The way I describe it is, if you go to a kid's Little League game, and if you know the rules are in place and the rules are being followed and the umpire is holding everybody to the rules, if your kid's team loses, you'll go home and feel, buy them a pizza and whatever. But if you feel like the game itself is rigged and not fair, and balls and strikes are being called in unfair ways, then people get angry, and that's the problem, I think. And we saw it with the Kavanaugh confirmation and how politicized that got. That's just unfortunate for the institution of the courts, in my view.
And the final thing I want to talk to you about is about the power of war. The biggest thing in the Constitution, one of the most enumerated powers, is the power of the Congress to declare war, to make sure that we don't get ourselves into a bad situation with an executive. Congress has basically abdicated its responsibility on this. What are your thoughts on the AUMF, the authorization of the use of military force? Right now, I actually asked President Trump on Monday, and he told me that he has the power to go to war with Iran, or to strike Iran, without any congressional approval whatsoever. What are your thoughts on the AUMF today?
Well, the AUMF talks about, if I recall, there's some limits on it, but in terms of having to have some terrorist implications.
Right.
That being said, to your point, Congress for many, many decades has not required a declaration of war to utilize military power in the executive. Scholars debate that. It's a chicken and egg thing. Some believe that once Congress creates a military, it's in the president's authority to execute use the military. Some believe that the president can respond to threats but can't actually declare war. But of course, then we saw this pre-authorization of war, as you mentioned, that George Bush used. And so the other thing I talk about in the book is, if there's a speed camera, or if there's a red light and people are not ticketed for blowing through the red light becomes irrelevant.
Yes.
And I think the war power declaration, that requirement, is like one of those things. We might as well get the Sharpie out and cross it out of the Constitution. Emoluments clause, other parts of the Constitution, if we don't enforce them, they're not meaningful. And I think that's something a lot of people don't understand. They just think the Constitution's there to save us, but it's not if we don't enforce it.
All right, and you wrote about that in The Hill recently.
Yes, I did. I wrote a piece
So check that out on thehill.com and get our own little plug. Well, let's talk a little bit, one question about your book. What's the most important thing people need to know about how to read the Constitution, and why? Why should they pick up this book?
Because it'll show you how to ride the Constitution bike, not just watch someone ride the Constitution bike. That meaning that if you log in or get on Wikipedia, Google the Constitution, you will get a description of the Constitution. This explains how it works in common sense language using analogies. It pulls out the sort of highlights the key provisions of the Constitution, starts with the text, and it has takeaways like we talked about, no Constitution cop on the block. It talks about this notion of strict reading of the Constitution, which is really malarkey because it's an old document. It requires an interpretation. We're talking about Supreme Court interpretations of the Constitution this week. I think it's really important for demystifying something that's quite intimidating for regular people, but absolutely foundational if we want to retain our individual liberties, which which is really why we have a structure in the Constitution that holds every elected official accountable to the people, is so that we're not bullied based on things that aren't fair to be bullied about. So that's why I think it's a civic education for everyone.
So where can people buy it?
Everywhere. It's on the HarperCollins website. It's on Amazon. You can look at my website, kimwehle.com. And also, if you want to listen to my voice some more, I did the audiobook as well.
There we go. All right.
Awesome. I feel like I've been to law school this morning.
Yeah, I know.
Great. But thank you so much for
It tries
being
to do
here.
that, yeah.
Thank you, Kim.
It's good.
Next on Rising, as both Democrats and Republicans continue debating Medicare, how will the discussions actually evolve?
Former Congresswoman Allison Schwartz shares her theories on that and discusses the current challenges facing the system as Rising rolls on.